So hopefully you can see my document, which has like a lot of word text on it. Okay, good. So we're talking about hearsay, which is rules 801, 802, 803, and we're not going to bother with 804, 805 today because they're kind of good to know, but you don't like really need to, for this, we don't need to know them. So we're going to talk 801, 802, 803. Okay. Most people have like a basic understanding of what hearsay is. It's like you don't want things that are said out of court to be used against people in court. That's like the basic idea. That is absolutely right. So to get into kind of the nitty-gritty part of it, and just to give you an idea, 801 is the actual definition of hearsay. So it tells us what are we talking about when we're talking about hearsay. And just to help you in kind of a macro idea with the rules of evidence, the way the rules are organized is that for relevance and for hearsay, they kind of mirror each other. So 401 is the definition of relevant evidence. 801 is the definition of hearsay. 402 is the objection that irrelevant evidence is inadmissible. 802 is the objection that hearsay is inadmissible. 403 are the exceptions that sometimes relevant evidence is kept out. 803 are the exceptions that sometimes hearsay is allowed in. You don't have to have that memorized. It's just something that I think is helpful in terms of in terms of, because you will kind of pick up and memorize the rules just by using them. And that's kind of an interesting way that they're organized. So we're going to start with the definition of hearsay. And I will preface this a little bit with, well, okay, actually I won't because that's more confusing. All right, so we're going to go. So you will hear the definition of hearsay a million times in mock trial. People say this definition all the time. It's like the most popular thing in an objection battle to say. It is a statement offered for the truth of the matter asserted, issued by a declarant. That last one doesn't really matter, but it's a statement, out of court statement, offered for the truth of the matter asserted. That's really what you need to take away. Out of court statement, offered for the truth of the matter. Out of court, especially in mock trial, is pretty straightforward. Statement, we'll talk about that. It doesn't have to just be verbal. It can be written. It can be gestures. Like if you point to something, that's a statement, if you're intending to communicate something. It's basically anything that someone does or writes or says to communicate something to someone else. That's what they mean by a statement. The really tricky thing is intended for the truth of the matter asserted, which is, it sounds very complicated, but basically it means you are trying to get it into court because you want to prove that whatever the person is asserting is true. So what I mean by that is, let's say, for example, like that I say, my favorite color is blue. Okay, so that's a statement. I make it out of court, and you're trying to bring it in. So what I'm trying to assert, like, what am I trying to assert when I say my favorite color is blue?
That your favorite color is blue?
Yes, excellent, wonderful. Full points to Gabe. That's exactly right. So then you have to ask, why are they bringing this into court? Are they bringing it into court to prove that her favorite color is blue? Is that why it's relevant? If so, it's being offered for the truth of what I'm saying. It's being offered to prove that, in fact, my favorite color is blue. Okay. Now, you might, a lot of times, you bring in statements and you don't care if they're true or not. It's just important that they were said. So an example of this is like if I yell fire in a crowded movie theater, what's everyone going to do if I yell fire?
Run.
Yes, exactly. Perfect. Aces to Mario. Okay, so if I yell fire and everyone runs, what am I, as the person who yells fire, what am I trying to prove with that statement? Assuming like I'm, whatever, just, on its face, what am I trying to prove when I say fire?
That there is a fire?
Yes, exactly. So if you actually are using the statement to prove that there was, in fact, a fire, then you're using it for the truth of the matter asserted. but you could be using it just to explain why everyone's running. Maybe that's what's relevant. Maybe it's relevant that, you know, that people were running at that time. So then you're bringing in the statement, not because you're actually trying to prove that there was a fire, but because you're trying to explain my words' effect on the listener. That's a super, super common way that things are not hearsay. Like, Your Honor, we don't care if there was a fire in the theater. What we okay, what we care about is that people were running, and this makes it more likely that people were running. Whether there was a fire is totally irrelevant to us. Okay, does that make sense? Just like that kind of basic concept? Do we have questions? Okay, so far so good. Okay.
If
Yeah.
So what if somebody testifies in trial that somebody else said something? That's an example of hearsay? So like you're crossing you're examining the detective, and he testifies, hey, I talked to the shop clerk and the shop clerk said X, and you're offering it to prove that what the shop clerk said is true. Is that hearsay?
Yeah, so if the defendant is on the stand and he's saying, Mark told me, you're in hearsay land, because whatever Mark said is out of court, assuming you're offering it to prove that, you know, that what Mark was intending to communicate, that's what you're actually trying to prove is true, then that's going to be hearsay.
Does it matter if the person's acting in a sort of official capacity? So like if specifically you have the detective of the case on the stand, can he testify to what different people said to him while he was investigating?
So the answer is maybe. He could, for one reason he might be able to is if he's an expert, which we won't talk about now, but there are some special things when someone's an expert that they could bring in hearsay. But he could also testify to it. Like, for example, it is possible that if if the person is saying, like, I saw the defendant do this, you could make the argument, and then let's say that the detective arrests this person. You could make the argument that the reason you're offering it is to explain why the detective arrested the defendant. You're using it to show the word's effect on the detective. Of course, then you kind of have to concede that, Your Honor, we don't care if he actually saw the person do this. All we care about is that it made the detective arrest him. Does that make sense? So what happens a lot of times, just in terms of thinking about this, because I will say effect on the listener is probably the most common way people get what would otherwise be hearsay into evidence, because they say, we don't care that this statement is true. We care about what its effect was on other people. Okay, when you're thinking about this in terms of responding to an objection, this is what's going to happen. They're going to object to hearsay. Objection, Your Honor, hearsay. You're going to respond, Your Honor, this is not for the truth of the matter asserted. No one is going to tell you this, but at that point, the implicit question is, well, then what is the relevance of this statement? If it's not relevant because it's true, why is it relevant? Then at that point, you need to respond as though you're responding to a relevance objection. Your Honor, we're not offering this for the truth of the matter asserted. We're offering it because it shows the effect on the listener. And it's relevant that it caused this person to run because it showed that they weren't paying attention where they were going, made it more likely they were acting negligently, which makes it less likely we're liable today. Something like that, right? Okay, excellent. Okay. That is the most complex part of hearsay, is what is the truth of the matter and why are we offering it? If they're the same, it's hearsay. If they're not the same, it's not hearsay. If you take nothing else away from this, that is what you should take away from this. Okay, moving on to other things you might take away from this. So, here we are. Okay, I'm right on schedule. Okay, 3 big reasons it's not offered for the truth of the matter is effect on the listener. And then, as I was saying, if you're responding to this, you need to say, it's not hearsay because it's not being offered for the truth of the matter asserted, then you need to explain why it is relevant. It's being offered to show X, and X is relevant because, and then you're in. Okay, are we together on that, like effect, how you would respond to that kind of objection? Yeah, okay. And like with practice, this will come, but that's kind of how you want to think about it. Okay, the next big reason something might not be hearsay is if you're offering it for impeachment purposes. So, for example, this is kind of two layers I will go with. I will go with the first layer. The first layer is, let's say I take a deposition before I get on the stand, and I say my favorite color is red. Then I get on the stand and I say, well, actually my favorite color is blue. You want to bring in that deposition to show that I've changed my answer, okay? Now, we'll just do a little pop quiz here. Okay, when I said in the deposition, my favorite color is red, what was the truth of the matter asserted?
What your favorite color is?
Yeah, that my favorite color actually is red. That's exactly right. When you're bringing it in after I've said my favorite color is blue, what is the relevance of bringing in this previous statement?
Because it directly contradicts what you just said.
Yeah,
Or, yeah, on the stand.
that's exactly right. And so why is that relevant?
Because if the matter at hand is what your favorite color is and what you have on the record, your sworn testimony or your affidavit says that your favorite color is one thing, and then you bring it up and it's something different, then you're like, which one is true?
Yeah, that's exactly right. And what you're getting at is exactly right. It's the credibility. You're calling into question my credibility. So in that sense, when you bring in the statement that my favorite color was red, when in fact I'm saying now it's blue, you're not really bringing it in necessarily to prove that my favorite color actually is red. That's not, you're bringing it in because you're showing that this witness isn't credible. She can't keep her story straight. She's lying on the stand for some reason, or her memory's faded, or whatever. So one argument you can make is this is not hearsay because we're not offering it to show XYZ. We're offering it to show she's not credible. And as you'll learn, credibility is always at issue. It is always relevant. It can be brought in that way. Okay, that's one truth. You can definitely do that. Alternatively, there is this exception, or not exception, under Rule 801D1A, which I have here. You can also bring it in if it's a prior statement that is inconsistent and was given under penalty of perjury at trial, hearing, deposition. The difference between these two approaches is this. In the first approach with credibility, you have to tell the judge, we don't care if what was said in the statement was true. That's not why we care about it. It's only credibility. This other approach, 801D1A, you can actually bring it in and say, we do care. This is the truth. She's lying now. We are asserting that this is true. Does that make sense, the difference between the two? Okay. And I will just tell you just the policy reasons behind this are we have a thought that earlier in time, your memory might be better. You might have an incentive to lie by the time you get on the stand. I think it's mostly a memory thing. But there's this, so basically you can bring it in as like substantively, this is what we're asserting is true. The caveat is you can only do it if it was given under these limited set of circumstances. So if you have a deposition, you can bring it in substantively under 801D1A. If it's like just a text message or something like that, you can bring it in for credibility under it's not being offered for the truth of the matter. Okay, good. That is impeachment. The relevance is credibility is always at issue. I think it's 608, 609. Okay, the last major reason why something is not hearsay is if it's a party opponent statement, which is 801 D2A, which you will have memorized like that. It will roll right off your tongue. Opposing party statement. This is the easiest thing. Basically, if you're on prosecution, anything the defendant says ever is coming in. That's just how it is. No objection, no nothing. It's coming in. Everything. So let that be a lesson to all of you. Literally anything you can and will say your entire life can come in against you. No questions asked. If you're on the defense,
What about the defendant's statements as reported by somebody else? Then hearsay.
so if you're coming up and you're saying like let's say I'm Laura and I'm saying the defendant told me XYZ,
Yep.
it's coming in.
Oh, really?
Yeah.
Okay.
Anything the defendant says comes in. Now, something I think we've kind of hinted at, which we can get into, is 805, which I kind of omitted, but we'll just talk about it now, talks about, like, imagine Russian dolls of hearsay. So let's say that, like, I say, my friend Emily told me that the defendant told her X, right? So it's like 2 layers now. All 805 says is that is not automatically inadmissible. So what you have to do is you've got to go through the Russian dolls and figure out if each statement can come in. So for example, the defendant's statement, the small Russian doll, that can come in because it's a defendant's statement. Now the question is, can my statement, Emily told me, can that come in? Anyway, we don't have to get into that, but the point is you can get multiple layers of hearsay in, but each layer has to satisfy some reason why it can come in. Okay. That's 801.
What's the disincentive for a lawyer intentionally bringing in hearsay just to expose the jury to the information, even if it gets stricken from the record?
Well, that is an excellent question, Mario. Yes. And what you will find is that people do a lot of times allege, like, well, we're not using this for the truth of the matter. We just want it for this. And you're like, it really seems like you want this to prove that what's being said is true. Kind of 2 things I think you brought up. One, once you say it, I mean, you're right. You can't, they say you can't unring the bell. It's wrong. It's out there. The jury's heard it. And there's really no way on the back end to cure that except for the judge to offer an instruction that says disregard that. Now, I mean, if someone says, like, Your Honor will offer a limiting instruction, you got to think, like, how effective is that? Like, can the jury really forget what they just heard? Also, when you're making your objections, you want to be, like, really, you know, you might want to preempt what they're saying and be like, Your Honor, like, we don't want the jury to hear this because you can't unring the bell. Now, you could also argue, as we talked, you could also argue 403 more prejudicial than probative or misleading the jury and say, like, there's no way the jury can keep that straight. It's going to mislead them. They're going to think it's true, or the mild probative value of getting this in to show effect on the listener is substantially outweighed by, like, how prejudicial it is to hear the defendant admit he's guilty, you know, and you can make that objection. Good question. Okay, 802 comparatively is super straightforward. Hearsay is inadmissible. That's all it says. So if something is out of court statement offered for the truth of the matter asserted, not an opposing party statement, it's inadmissible mostly. Okay, 803 are our exceptions. Sometimes, even if it's hearsay, we're gonna let it in. And just as a note, 403, as y'all may be aware of, but just in case you're not, 403, there's like a standard. 403 is sometimes relevant evidence. will be kept out. And there's a standard. It'll only be kept out if it's substantially more X than relevant. Worth noting that in 803, there is no similar standard. There's no substantially more. It's just sometimes they can come in. Okay, no one expects you to have all of the hearsay exceptions memorized. There are like a lot of them. This isn't even all of them. I think I just stopped copying after a while. So you don't have to have all the hearsay exceptions memorized. A lot of times teams, when they really want something in, will just kind of read through them to see if anything sticks out as like, this is something we can use. There's no problem at all if you're being hit with something you haven't heard to be like, Your Honor, like, can I just have a minute? And you can like, actually a lot of people on this team carry around federal rules of evidence packets. And in trial, it's totally fine to look at it and kind of read it. And they're pretty straightforward. They're pretty much plain language and be like, okay, it's not going to apply because of this. That doesn't really happen that much, but I want to put you all at ease that there is no pressure to memorize all of 803. I'm just going to talk about a couple of really commonplace ones that people kind of know off the top of their head, and incidentally, they go in order. Okay, present sense impression is like you are witnessing something and you are saying it in the moment you are witnessing it. So like you're watching a car crash and you're like, oh my gosh, that car is moving so fast. It's moving so fast. Those statements could come in. Even if you're offering them proof that the car was moving fast, they can come in. Excited utterance. This, to some extent, is a little bit broader. It should be pretty close to when the event happened, but the big language is like it's made while the declarant was still under the stress of excitement. So it doesn't have to be contemporaneous. It could be like even maybe, I don't know, whatever, an hour went by. If you still are like under trauma, you're like, you know, in theory, we assume that whatever you're saying is true. I don't know. Then existing mental, emotional, or physical condition, like I'm happy, I'm sad, those can come in. If you're talking to a doctor for medical treatment, like you're explaining your symptoms, those can come in. I don't know. We don't have to spend too much time on this because you can get into it if you need these exceptions.
That's surprising to me, considering that sounds like confidentiality issues.
Yeah. It's interesting. I won't bore you with my whole evidence class right now, but all these exceptions are basically linked to the idea that we think you won't lie when you're making these statements. So the thought is like, there's an incentive to be honest with your doctor. I guess you're right. I mean, there could be other rules that might keep those statements out, like maybe confidentiality. But in terms of hearsay, we assume it's pretty credible, so we'll let it in. Two kind of big things that are good to know are 8035 and 8036. 8035, okay. 8035 is a recorded recollection, which is this. Here's what it is. So you can use, so forget 803 for a sec, forget the federal rules of evidence. You can use anything in the world to refresh a witness's memory. Like you can play a song, you could say a word, whatever. Anything, if your witness gets on the stand and says like, I just don't remember, you can say anything to them pretty much. And if it jogs their memory, then they can testify just like they normally would. If you actually want the thing to be read into evidence because they've forgotten and you're trying to jog it, and they're just not getting it. And you hand them the document, they're like, I'm sorry, it's not refreshing my memory, I don't get it. You can actually have the thing read into evidence under 8035. And you just need to meet these three criteria. Okay. But if your witness gets on the stand, and sometimes people will do this and they forget, witnesses forget, that's fine. You can just say like, would you like me to refresh your recollection? And then if they say yes, technically, although mock trials gets fuzzy, technically you're just supposed to hand them the document. They're just supposed to read it, and then they're supposed to testify independently of that document. If you want the actual substance read into evidence, then you need to do 8035. And even then, you can't admit the document into evidence. It's only going to be read into evidence. Okay, the last big thing, and this comes up a lot, is 8036, business records. or records of regularly conducted activity. The idea is that businesses rely on these, stockholders rely on these. In theory, these are like routine practice you do all the time. They should be reliable. What is a business record? Record is like a subject of a lot of controversy in the mock trial world. A lot of things try to get like squirreled in under this exception. The big thing is if you meet these 5 criteria, it should come in. So the record is supposed to be made by someone near at the time, someone with knowledge. It's kept in the course of regularly conducted activity. Making the record is a regular practice of the activity. And then the person testifying doesn't have to be the person who made the record. It just has to be someone like associated with the business who can attest to the fact that this is in fact something the business does with regularity. Like emails, amazingly, come in. A lot of company emails come in under business record act. Like this is kind of real world stuff. In the mock trial world, because we're so hyper technical on these things, sometimes it needs to be more formal, but in theory, like anything that the company does with regularity, it should come in. Okay, and that's pretty much, I'm gonna stop sharing because I know it's like annoying. That's pretty much hearsay. Like if you know all that, you're gonna be in a really good spot.